And that concludes questions or oral answer. I have received a letter from Stuart Nash seeking to debate under Standing Order 389 the increase in the number of recorded burglary victimisations by 14% in the last 12 months. The urgent debate is a way of holding the government accountable for an action for which it is responsible and must relate to a particular case of recent occurrence. The urgent debate procedure is not intended to address a continuing problem such as burglary statistics, which do not constitute a particular case of recent occurrence, and I refer members to Speaker's ruling 2105 and 2106. On this basis, the case raised does not meet the test for me to set aside the business of the House today. The application is therefore declined. Order. The Honourable Gerry Brownlee.
Mr Speaker, I move that urgency be accorded the introduction and passing through all stages of the Housing Legislation Amendment Bill. Mr Speaker, this bill will allow the extension of special housing areas throughout the country.
Order. It is very unusual, but on this occasion a point of order has been called. I will hear it.
The reason I'm calling a point of order, Mr Speaker, is that this bill has been introduced as an omnibus bill under Standing Order 263A when it is not an omnibus bill. And the reason I say that, Mr Speaker, is that it meets neither of the two requirements in Standing Order 263A. And the first point is this. The topics of the two amendments are not interrelated, and the term interrelated, according to the dictionary, means reciprocally or mutually related. And that means each of the amendments must demonstrate either some reciprocity within a purpose or some mutuality of a purpose. And in fact, these two measures don't do either of those things. One deals specifically with time limits for special housing areas, and the other deals specifically with offer-back provisions when state housing land is sold. So there is neither any reciprocity in purpose nor any mutuality of purpose. The second reason, Mr Speaker, is that the other requirement is that it should implement a single broad policy according to the Standing Order. And in fact, one purpose in this bill is the development of land for sale, and the other affects social housing policy and especially the sale of it. So one policy relates to the development of land for sale and the other the sale of state housing land. Neither thing is related to each other at all in any policy context.
I need no assistance, and I do thank members for offering their assistance. My office and myself had a good look at this earlier today. The bill does two things in order to increase the supply and the affordability of housing. It makes amendments to the Housing Accords and Special Housing Areas Act 2013. And secondly, it amends the Housing Act 1955 to clarify how the Public Works Act 1981 applies to the disposal of state housing land for the use for housing purposes. Both relate to the stated purpose of increasing supply and affordability of land. It is in order and does comply. Order. I hear an interjection like that again, I'll be asking someone to leave. I am ruling that it does comply with Standing Order 263A. Point of order. Just before I need to clarify, I have ruled quite categorically on whether this bill does comply. The member is absolutely free to raise any point of order on another matter unrelated to this. But if the member rises to his feet and continues now to argue when I have given such a categoric ruling on this matter, that in itself will lead to disorder, and I will consider very carefully whether I'd be asking the member to leave. Point of order, Grant Robertson.
Mr Speaker, it is a new matter regarding whether or not a bill that is introduced under 263A can be considered to be implementing a single broad policy when there is in this bill, in Part 2, is in fact an amendment that relates largely to the Public Works Act and does require no obligation for land freed up under that to be used for housing. So there's no obligation. So that is actually not even the outcome of this is not even related to housing in the end. The obligation, there is no obligation for that land to be used for housing. So the only way, my view, that this can be seen as an omnibus bill is to create such a wide definition of a single broad policy as to be meaningless, Mr. Speaker.
I will hear from the Honourable Dr Nick Smith.
Mr. Speaker, I think the two previous speakers failed to understand the interaction between...
Order. And if I hear that member interjecting on a point of order again, I will be asking him to leave the chamber.
Mr. Speaker, Standing Order 263 requires that amendments deal with an interrelated topic. I would deal, for instance, very specifically with the very first special housing area in Weymouth is also exactly the land that is affected by the Housing Act provisions that are covered for in this bill. If we take one of the largest housing developments in Auckland at Hobsonville, actually the largest housing development currently in Australasia, it is both a special housing area affected by this bill. It is also affected by the Housing Act. In fact, that interrelationship applies to over 30 of the special housing areas. So I think the reason for the point of order is that members have not understood the connection between special housing areas and the Housing Act 1955.
I've spent some time on this matter. I have given a ruling. It's not a ruling I gave lightly. While I accept that members don't agree with what I've stated, we are moving forward. I've accepted that the bill does comply. The Honourable Gerry Brownlee.
Mr. Speaker, I think in that exchange there's been ample demonstration of the particularity that might be required to support the motion. What I will say, though, sir, is that this extends provisions for affordable housing that have been very successful to date, and I look forward to the whole House who have concerns about affordable housing offering their support for it, but of course recognise that given the previous exchange, there are likely to be spurious reasons why people will not support it.
Point of order. Chris Hipkins.
Mr. Speaker, the House has set down a procedure for a minister moving urgency to describe the nature of the urgency and why it is urgent. It does not allow for the minister to then use that as an opportunity to preempt what opposition members may say and to take a flick at other members of the House.
Order. No, there is certainly no need for the last part of the minister's statement to be given. What this is a chance for the minister to explain the reason for urgency. He has done that. It's no longer a debatable motion, and I will put the question. The question is that the motion be agreed to. Those of that opinion will say aye. Aye. To the contrary, no. No. A party vote has been called. Oh, very, very politely, I ask the clerk to conduct a party vote.
New Zealand National.
59 votes in favour.
New Zealand Labour.
32 votes opposed.
Green Party.
14 votes opposed.
New Zealand First.
12 votes opposed.
Māori Party.
2 votes in favour.
Order.
1 vote in favour.
United Future.
1 vote in favour.
The ayes are 63, the noes are 58. The motion is agreed to. I understand it is the intention of the government to introduce the bill.